In Whole Women's Health, the question in front of the Supreme Court is over 2013 law that the Texas legislature enacted. Essentially, Texas included a battery of requirements around pre-viability abortion and whether an abortion provider has to have admitting privileges at a local hospital and whether the abortion facility itself has to conform to rules for ambulatory surgery centers more generally, not just abortion clinics.
The constitutional issue in this case is the extent and scope of the regulatory authority of states regarding abortion.
So the question here is whether this combination of regulations either have the purpose of erecting a substantial roadblock on the path to a woman's right to abortion, or they have that effect. Under Casey, the court was very clear that the state cannot erect an undue burden to a woman's right to decide this matter for herself pre-viability.
The best argument for Texas is that these regulations actually came out of the Kermit Gosnell case in Philadelphia, an infamous case where the abortion provider was actually convicted of 3 murders and 1 manslaughter charge. And in the grand jury indictment in that case, they called for states to pass admitting privileges and to require clinics meet ambulatory surgical care centers. In this instance, what Texas is trying to do is to make sure that women who choose to end their pregnancies through abortion are safe and protected by laws that ensure doctors are qualified and that clinics have the proper equipment and procedures in place.
On Whole Women's Health side, they argue, I think, pretty convincingly that abortion is just not that big a deal in terms of safety.
Clearly ensuring that physicians who perform abortions are both competent, qualified, and committed to communicating with the local health authorities if a woman needs to go to the emergency room is something that advances women's health and safety and is well within the state's rights to regulate.
Here we have strong evidence that there will be, if nothing else changes, a loss of something like 75% of the existing abortion providers in the state. Women are going to have to drive farther. They are going to have to wait longer potentially, and it may well be more expensive. And all of that seems sort of silly if you think these procedures are already safe.
These regulations place no undue burden on the patients. It simply ensures that the providers who are taking care of them and who are assisting them with the desired operation are competent, qualified, and committed to their well-being.